So next we're going to hear from our DPI liaison, Christina Spector. She's going to talk to us about those IDEA complaints and maybe some trends or some highlights. Please welcome Christina.
Just so that they know what we're referring to. Thank you so much, Jane. Jane's going to pull up, you received electronically my outline. There's a lot of hyperlinks in there. So I didn't want to print it out because it's not as useful to you if you can't actually click on the hyperlinks themselves. So feel free to refer to that as we go along. I just wanted you to see, this is my data. And it was a lot of fun to read it. You can see how scientific it was. I had this at my kids' sporting event as I was tallying. So I have all of the actual complaints. If you're curious and want to see a paper version, feel free to come up here and take a peek. But I just also want to let you know how much I appreciate working with all of you. This is by far one of my favorite groups to work with. It's kind of the highlight of my job to get to work with so many like-minded, passionate people who have such a very, very broad skill set that they bring to the table for Wisconsin kids. It's absolutely critical for our families and our districts, and really most importantly, our students. So thank you for coming to work every day and giving it your all, even in really, really difficult situations. So as we wait for Jane's presentation to pop up, I think it's the spiral of death. And they make it a rainbow, so at least it's beautiful. Thank you. I'm just going to kind of go through some trends. There is no way that I'm going to get through all of this material in 30 minutes, so I apologize in advance, but there's just too much good stuff out there. So the first thing I want to mention is this is IDEA state complaint data, which is different than your data, right? We collect our data on a calendar year basis. So some of this might look a little different than what you're used to seeing. Many of your, when you look at your data, you look at it as a fiscal year. So it starts in July 1, or starts January 1. So it's not going to completely overlap if there's any data in your folders. But as you can see, as Barb mentioned, for the last couple of years, I have been around long enough doing complaints for about 10 years now that I've seen a couple of these trends. But we have had an uptick in the number of complaints and mediations in the last few years. Overall, we got the most mediation requests, followed by IDEA state complaints, and then due process hearing requests, which is, I mean, if you're thinking about the best way for families and districts to resolve disputes, I would say that that's exactly where we want it to be. We want people to resolve things informally whenever possible. So that makes me happy. So for the 2018 calendar year, as Barb mentioned, we received 98 state complaints to investigate. And then I kind of broke those down a little bit so that you could see where they came from and what happened with them. So 3 of those were never even acknowledged by our office because they were resolved informally, or a due process hearing request was requested at the exact same time. So we don't even need to acknowledge those because if we receive a request at the same time as we receive a due process request, we wait. It also makes me happy to hear that some people were able to resolve it completely outside of DPI even saying, yes, we received your complaint. So that's a really good sign, I think. So you take those 3 out that weren't even acknowledged, and there were 95 less, and we received, of those 95 complaints, 223 issues. So I don't know how much analogy that has to the work that you do, but for us, that means there was an average of 2.35 issues in each complaint. But as you can imagine, those range drastically. We had many complaints with only 1 issue that was acknowledged, 1 issue that was in dispute. We have many that have 5 to 7 issues in dispute, and one of my lucky colleagues even received a complaint to investigate with 11 issues in it last year. So I have a feeling you all lean more to the heavy side, right, than the simple side of that. But just to give you a sense that, you know, we see all kinds of complaints as well. We have, as of the day of writing this presentation about a month ago, we had issued 80 decisions of those 95, and we were still, just as you do, we have a little bit of a lag at the end of the year. Some of them were also in abeyance for various reasons. So 4 of the IDEA complaints that were filed went into abeyance or on hold because they requested a due process hearing on the exact same issues. So I said, we hold those for the due process hearing. Sometimes they come out, sometimes they don't. 6 of those went into abeyance because the parties agreed to attempt to resolve the issues through mediation. That's something that we always mention to folks when we receive a complaint is, did you know that there are other dispute resolution options available to you, and would you like to hear about them, and would you like to try them? So sometimes the parties will decide after filing a complaint that they actually want to try mediation. So you probably see some of those occasionally, right? So of those 6 that went to mediation, 3 of those 6 were withdrawn. So my assumption is, I don't ever know this for sure, but my assumption is that there was some sort of written agreement that resolved the dispute. 2 came back and were investigated, and as of the date that I wrote this, one of them was still in progress. So I think one thing that I learned this year that I wanted to be sure to pass along to you is that if there is a mediation that you're a part of that came out of a complaint that was originally filed, it would be a great idea to talk about that in your mediation and how the parties are going to move forward related to that complaint. I've seen that a couple times where, well, I guess not. I've seen that one time where it wasn't ever discussed what would happen to the complaint as a matter of fact for the mediation. So then we actually have to pick it up if we don't know that the parties resolved it. So then I did have to issue a decision. So make sure that you think about that if you know that you're getting a complaint that came out of, a mediation that came out of complaints.
Are all the complaints from parents, or are they from
No,
other parties?
that's an excellent question.
How do you address the confidentiality if they're from other parties?
Yeah, excellent question. So she asked, are the complaints always from families or parents, or do they come from anywhere? And they actually can come from anywhere. Anyone can file an IDEA state complaint. So I would say the majority of them come from families and parents, but we get them from advocacy organizations. We receive complaints from staff at schools, all different areas. And the IDEA state complaint process is not confidential. In order to file an IDEA state complaint, you have to be willing to give your name. And there is always some shuttle diplomacy that goes back and forth. So it's not a confidential, you can't anonymously file a complaint.
But what about when you're investigating things that are pupil records or things that would be confidential in your file?
You mean in terms of the investigator themselves? Excellent question. There is an exception in FERPA for state education agency staff. So we have the right to review any of those unredacted materials as part of FERPA. Is that what you meant?
So then the person who asked for the request, if they're not a parent,
Oh,
do they have access then?
excellent. Excellent. They do not. So if the person that filed the complaint is not a parent, how do we deal with them receiving, let's say, the acknowledgement letter or the decision at the end of the complaint process? Because DPI as an agency cannot share confidential information with parties. So we actually, early on in the process, if we receive a complaint from someone who is not a parent or someone with education decision-making authority, then we actually send a request to that person, to the parent or whoever has that authority, and say, we received a complaint from this person. Would it be okay if we share information with them and we get a waiver at that point? Or we don't, and then we don't share information and we can't interview the individual who actually filed the complaint. Does that answer your question? Great. Thank you for asking that. That was a great complaint. And I actually wrote here next in my list, I said, this gets really tricky when the filing party is not a parent, right? So she anticipated exactly what I was going to say. I thought it was really interesting and insightful that 10 IDEA state complaints were filed and withdrawn before a decision was ever issued. So the parties were able to resolve it before we ever got to the decision-making place. So when complaints are filed, we are required to provide a copy of the complaint to the district. So my assumption, whoever files the complaint is asked to send us a copy of the complaint that they're filing, but then also asked to send the district a copy as a heads up. And my assumption is that In that case, maybe the districts got the complaint and said, yes, the things that the parent are asking for are reasonable, and we're willing to work with the parent and try to resolve that informally. So I think also that's a really, really good sign that so many districts and families are willing to work together as a result of that. And then some of them were actually withdrawn after the acknowledgement. You'll see that 8. And so to me, that means, for whatever reason, after DPI said, yes, we received your complaint, the parties decided they wanted to work together and resolved it informally, which again, I think this is all very, very positive, exciting data. And then, you know, as Barb mentioned earlier, we continue to have a very, very effective mediation system because of your hard work. And many disputes are resolved either through a formal mediation or by a facilitated IEP, or even through a due process resolution meeting. So as you can see, we received 25 due process hearing requests last calendar year, and there were only 5 that resulted in an actual written decision. So what that tells me is that for whatever reason, probably likely the involvement of the folks in this room, 20 of those were resolved before they got to the point where the hearing officer had to issue a decision. So kudos to you. So let's talk a little bit about the kind of things, some interesting things that we saw in complaint decisions, and I'm just going to go through these really quickly. You going to scroll down a little bit for me? Thank you, Jane. So as a reminder, for the IDEA state complaint process, OSEP has said that there's no particular burden of proof. The state agency must conduct an independent investigation, and these are just things that I thought were interesting. They don't have any particular reason other than I thought that they might be somehow overlapping with your work as mediators, so that's why I wanted to point them out to you. So the first one I wanted to point out is 1860, and I think this reminded me of the importance that districts need to really focus on determining who is the parent under special education law, because it's different than a lot of times what people would think it is. So, and it's a step that I think often gets forgotten because it's very early on in the process. IDE states that a number of definitions under 34 CFR 330. However, it allows foster parents to serve unless prohibited by state law. But here's the important part. In Wisconsin, a parent for the purpose of special education law is defined in our state law in Chapter 115. In general, foster parents have the rights and responsibilities, but only if a district first determines that the legal right of the student's parents to make educational decision-making authority has been extinguished or terminated, and a transfership has been done of legal custody or by other court order. So I think a lot of foster parents are very surprised by this. So I just wanted to point it out so that you all knew. I'm sure that you've come across this in your work, but every time I present in front of a group of foster parents, there's always kind of an audible gasp. So I want to make sure that this is really clear and out there. We did receive a whole bunch of complaints, you can see them all hyperlinked in here, on pupil records law this year. And so I wanted to be sure to include those. We do address these under special education complaints because while they largely mirror FERPA, there is also a section in IDEA that specifically relates to pupil records. And we must address any IDEA requirement in our process. So that's why we look at pupil records. The first group of cases concerns when access to pupil records must be provided. So under IDEA, a school district has to comply with a records request without unnecessary delay, number one, and before any IEP team meeting. And they fleshed out what is unnecessary delay. So in all cases, they have to be provided within 45 days. So something to keep in mind when a parent makes a request, the access must be before the IEP team meeting. And we do consider when the request was made and the scope of the request when we look at IDEA state complaints. So for example, in one of these complaints, we found that a district had 10 business days before the IEP team meeting to comply, and this was generally sufficient to comply with the request given that particular scope. So they're all individualized, so we really caution people not to make too many generalizations, but based on this facts, we determined it was enough. However, in another complaint, we found that given the scope of the request, which was very, very broad, and it was less than 2 days before the IEP team meeting, it wasn't sufficient time. That was 18025. However, districts should always provide as much as they can before the IEP team meeting. We also received a lot of complaints around placement determinations, and we just wanted to make a couple points related to that while we had the chance. And I know that you see this often in your work as well. The IEP needs to clearly and consistently describe the extent of removal from special education. And we see this as such a problem that this is actually part of our self-assessment monitoring. So we look at this in all of the districts throughout Wisconsin on a 5-year cycle, that the IEP reflects the extent of removal. So for example, in one case, the IEP stated that the student will spend as much time as appropriately possible in the regular ed time, including those times with recess, PE, special activities, and free time. And the parent believed that the student was not regularly getting that. And we did find that the IEP didn't sufficiently address how much time the student was going to be removed. So the language, as you can imagine, was very broad. It was as much time as appropriately possible. That doesn't really explain the extent of the removal. We'd hope every child was in with their general ed peers as much as reasonably appropriate all the time, but that's not an appropriate language to use for IEPs. Another point that we wanted to highlight, again, based on complaint decisions, is that placement decisions must be made by the IEP team at the IEP team meeting. So this is a Wisconsin-specific requirement. We're unique here in the state that placement determinations are made by IEP teams at IEP team meetings. So for example, in one case, a district staff member decided that homebound services for the student would no longer be provided. And this was done outside of an IEP team meeting, and that was complaint 18027. That was actually one of the complaints I investigated. And another important side note, because I know you see homebound service cases in your work, in determining homebound services, the IEP team should certainly consider any medical information provided, but the IEP team does not need verification from a medical provider, and a medical provider cannot write a prescription for homebound services. Okay, those were issues in this complaint as well. They had it in their district policy that they needed a letter from a doctor in order to do homebound services, and that's just not the case. It's an IEP team determination based on what the child's needs are. Yeah.
There are still some physicians who write prescription for special education. And I've seen those. Our state organization, the Medical Association of Wisconsin, and in one of their previous newsletters, they clarified this. Are we still getting that?
Yeah.
If we feel of any district that received that, we send them the link to that newsletter from the Medical Association.
Fabulous. I'm glad to hear that. Yeah, we do have a lot of just misknowledge between the medical community and the educational community, and I've seen this in quite a few complaints. And I will say that I think the best way to combat that is for school districts to proactively reach out to the medical providers in their area and explain to them, if you have concerns about a kid, we want to hear them. Here's our referral form. You're actually obligated under state law to make referrals if you believe a child has a disability. Here's our referral form if you want to do that. So I think the more outreach that people can do related to Child Find is really, really helpful in building these bridges. I just investigated a complaint a couple months ago where a physician repeatedly attempted to contact a school district, and the school district said, we never got the letters. So there was just a blatant miscommunication there. And it was because the building where the school was a K-12 building, and they had, 5 different offices. So they have no idea where the letter went to. And the district didn't really understand that they could proactively reach out to the medical community and say, not about a specific child, obviously. You can't reach out and say, hey, this kid, right, because they're still covered under FERPA, but they can reach out and say, in general, this is our process for referring kids, and we want to make sure that we're reaching kids, and if you have concerns, this is the person to speak with, and this is who to reach out to. Any other questions about that? These are great points. I always appreciate it. Yes, Jim?
About an IEP student, say, going through a student that has surgery,
Uh-huh.
does the IEP team need to convene and incorporate that into the IEP?
Yeah, I think that's a great question. Did everybody hear it?
Can you repeat
Okay, absolutely. So Jim said if you have a student who has an IEP and then they have, let's say, an orthopedically impaired student and they have surgery, would that be something that the IEP team would need to address? And I would say not always, it depends, but it's always good practice to reconvene as an IEP team meeting and talk about different, maybe the student needs a different transportation arrangement, or maybe there's different things that the student might need. So yeah, if a student needs to be on homebound, again, absolutely, that has to be an IEP team decision made in an IEP team meeting. So absolutely, in the case where a team is considering homebound, there should be an IEP team meeting, definitely. Thank you. All right. Also, another thing that districts really need to be careful of in IEP teams is to make sure that placement is not predetermined and that all possible options are considered and discussed at the IEP team meeting. And even better yet, they should document it. There's a page on the placement page of special ed forms where they can say, what are the other options that you considered and you decided not to go with and why? And this would be a perfect place to document those kind of conversations. You know, whenever you go to an IEPT meeting, you have a conversation about all of the continuum of options of placements that are available. So in one case, the district offered the parent 2 placement options. They said you can either have homebound or you can have a private placement. And the parent wanted to discuss other options, but it wasn't permitted at the IEPT meeting. So that was a violation in 18029. We found that the district did not determine placement through the IEPT meeting. It was a predetermined placement, and it wasn't properly determined within regards to the least restrictive environment. I'm going to jump forward a little bit. We had a couple more placement cases, but I think you get the drift. And talk a little bit about evaluations. And I do want to mention that we did throughout the last year get quite a few complaints where the student was medically diagnosed with autism, but then did not qualify under the educational impairment area of autism, and then the parent filed a complaint as a result. And this can certainly be the case, and as we discussed just a few minutes ago, a medical diagnosis does not automatically qualify a student for special education services. The case listed in the outline is about screening versus evaluation, another interesting distinction in our work. The facts presented in this case, again, this was a case-specific analysis. The staff performed a number of observations on the student, which they are required to do as part of an evaluation. And they were focused on that student's performance in the particular classroom in order to determine whether or not that student would qualify as a student with a disability under IDEA, and then what kind of services would be needed as a result. Those observations included an analysis of this particular student's time on task, and they included a narrative summary of the observations with data in the evaluation report, but did not get consent for the parent for the evaluation. So this spelled out an IDEA, and 310 would not meet the definition of screening for instructional purposes. So there is a distinction for what screening is in the regulations, but this was definitely more individualized and specific than that, screening for instructional purposes. So if folks are going to do individualized looks at kids, observations to determine what kind of services, they need to receive consent from the parent as part of the evaluation process. So the next part that we're going to look at, we actually also look at through the IDEA state complaint process. And as part of the annual meeting, and more often if necessary, as you all know, in the world post-Andrew F., the IEP team must review the annual goals and determine if they're being met, and if they're not being met, revise the IEP accordingly. In order to do so, the goals have to have a level of attainment that relates to the baseline, and there must be a way to measure progress that matches both the level of attainment and the baseline. So in other words, you can't compare apples to oranges, it all has to match. So what I see in practical reality is that, for instance, you have a student who has an annual goal related to reading, and let's just say that the goal is that they will reach a level 4.0 in STAR. That's a kind of assessment that can be done in reading. And their baseline is 3.0, so 3rd grade reading level on the STAR. And then it'll say something like, we're going to use running records with Fontes and Pinnell in order to measure that. So while they're all very valid, great ways to measure reading progress, Fontes and Pinnell, running records, you know, if you've gone to your child's elementary school parent-teacher conferences, that's the letter A, B, C, D, E. They give the levels that way. Doesn't relate to the level STAR assessment, so therefore it would be impossible to use that to measure whether they're from a 3.0 grade level to a 4.0 grade level on STAR. So that's what we're saying. They just all have to match in order to make sure that the family understands, the parents understand, the school staff understands what's going to be measured.
I had a question that one, or not a question, a statement made at a mediation, which is fine that they make it, but they, the district says that DPI has told them that baselines in reading achievement all have to be based on a test, the same test. Is that something
No.
that is true?
No, DPI is not in the, I'll repeat the question, sorry. She said that she overheard at a mediation that DPI said that all reading goals have to be based on a common test for a baseline. So meaning that we say that such and such assessment is how we measure reading in Wisconsin, and therefore every reading goal has to include that, and that's just not the case. We're a local control state in Wisconsin, so districts and IEP teams have the authority to decide which test they're going to use, but it needs to be reflected in the baseline and in the level of attainment.
Even if they chose a test and then apply it, if that's the, they have to apply it to uniformly to all their kids in special ed, to me, that sort of seems like you're going away from individualized, measuring
Yeah,
a goal and an
yeah,
attainment by a specific instrument for each and every child.
interesting. Yeah, so what she's saying is that in that district she was working in, they were all using the same test for all of their special ed students as a baseline, and she felt that that was missing the individualization part of the IEP. Okay. She just thought it in her head while she was mediating and being impartial. It's a good thing to just have a little conversation with in your own head. Yeah, we don't get that detailed. You know, we wouldn't say it's, you know, there is district, you know, option to choose which assessments they're going to use, and there is some flexibility in terms of what they would order of their staff, let's say. But I would also say that, yeah, it is important to be individualized and to make sure that we're building goals around what kids actually need and where their gaps are, because they can be a lot of different places in reading. Yes, thank you, Jane. Yes, Daryl.
Under evaluation, case 18062, how are you defining the term screening?
That's an excellent question. Daryl's going back to evaluation. He wanted to know about case 18062 and how did we define screening. And we define it under the regs in IDEA, which are 34 CFR 300-302. And that's the definition of screening for instructional purposes. So if you just Google 34 CFR 300.302, it'll pull it up. And it actually gives a really nice definition of what it is. Instructional purposes mean screening like I'm trying to decide what to teach this child next. In terms of a regular ed teacher, right? Versus I'm looking at this child as part of their annual IEP to determine what would a reasonable goal be and what kind of services will this child need. It's a tricky distinction. I would love to talk more about that with you one-on-one if you'd like.
Well, I'm looking at the term screening versus student use special education eligibility and educational needs. And then you say, I'm not screening.
Did you get there, or do you want to talk about it later?
We'll talk about it.
Sounds good. I have the case right here if we want to look at it together. This is exactly why I brought my data. All right, I only have a couple minutes left, so rather than just churning through, any last minute thoughts, questions, burning needs that I can help you with? Or do you want to just take the time and we'll let Jane get an early start?
Well, now that you mention it,
I can always count on Daryl for good questions.
under placement, case 18062,
It's the same one.
it is.
Mm-hmm.
So, needless to say, this alternative, continuum of alternative placement, my experience has
Exactly, that's why I pointed it out. Yeah, Gerald said he is concerned in his experience that there isn't a continuum of placement options that are considered, and I would say some districts are really, really good at offering a continuum, and some need some work in this area. So that's exactly why I pointed that out, is that it's important to have a continuum available. Obviously, these change with the reality of what's available locally, right? But it's important to have that conversation, and that it's not just a choice between one placement or two placements, that you have a full and open and honest conversation. I would say another kind of stake in the heart of that case was that they didn't allow any other conversation about any other placement options. That's also really important to think about. Like, it was a stifling of the conversation about placement at the IEP team meeting, right? All right, well, thank you so much for your time. And again, if you have any questions, I'll be here all day. Feel free to come up and ask me, but I really appreciate you and all your hard work, and thank you for your time.